Today we'll be discussing the fair lending laws, starting with Equal Credit Opportunity Act, also known as ECOA, which applies to any extension of credit including residential real estate lending. UDAPs, which are unfair, deceptive, or abusive acts and practices. And the Fair Housing Act, which regulates residential real estate related transactions. Together, these regulations are called the fair lending laws. First, let's cover prohibited practices and ECOA requirements. There are 10 prohibited factors when combining the requirements of ECOA and the Fair Housing Act. They are race, color, religion, gender, national origin, disability, familial status, or presence of children in the household, marital status, age, provided that the applicant has a capacity to contract, and finally, if the client receives income derived from any public assistance program or has exercised any right under the Consumer Credit Protection Act, the CCPA. Recently, HUD made clear that they interpret the Fair Housing Act to also bar discrimination under the basis of sexual orientation and gender identity. Unequal treatment based on any of these prohibited factors would be a violation of the regulation. Various state laws also govern fair lending, including but not limited to New York Executive Law 296-A, which makes it an unlawful discriminatory practice for any creditor to discriminate against any applicant because of sexual orientation, sexual identity or expression, creed or military status, in addition to the prohibited factors we just talked about. Here's what can't be done based on any of the prohibited factors. The creditor cannot fail to provide different information or services relating to any aspect of the lending process, such as product availability, application procedures, and underwriting standards. Discourage or selectively encourage applicants with respect to inquiring or submitting an application, refuse to extend credit or use different standards in determining whether to approve an applicant for a loan, vary the loan terms offered from one applicant to another, treat a client differently in the servicing of their loan or when invoking default remedies, and finally, different standards can't be used for pooling or packaging a loan in the secondary market on the basis of a prohibited factor. Let's talk more about the regulations themselves. Remember the prohibited factors under ECOA and the Fair Housing Act? The mortgage industry is required to ask about and report on some of the factors even though they can't influence their decision. This is so the government can be sure lenders are complying with ECOA. The factors asked about are race, ethnicity, sex, marital status, and age. The applicant can choose not to provide the information, but they are encouraged to provide it. Ultimately, this information is part of the HMDA data reported to the government. Here are some other ECOA requirements. A joint borrower or cosigner cannot be required when someone qualifies for a mortgage loan on their own. Require that the cosigner be the applicant's spouse when a cosigner is applying for the loan. Allow a client's age, loss of employment, name change, or change in marital status to be a reason for terminating or restructuring an existing loan. And additional personal information or personal guarantee cannot be required on the basis of a prohibited factor. Now let's talk about predatory lending. Predatory lending practices include failing to fully disclose or explain the true costs and risks of loan transactions, charging clients unearned, concealed, or unwarranted fees, encouraging clients to refinance loans just so the lender or originator can make money, and making loans with terms and structures that make it almost impossible for the people to reduce their debt. And there are other legal practices under the fair lending laws. Redlining, a form of illegal disparate treatment whereby a lender provides unequal access to credit or unequal terms of credit based on any of the prohibited factors with respect to the residents of the area where the applicant lives or plans to live, or the location of the property to be mortgaged. Racial steering, persuading clients away from certain neighborhoods for racial reasons. Discriminatory appraisals, completing an appraisal that reflects a value based on racial characteristics of the homeowner and/or within a neighborhood. Discouraging certain applicants from applying for credit, having inconsistent underwriting standards which require excessive standards or documentation, and varying the terms of credit offered, including the interest rate, duration, and type of loan based on any of the prohibited factors. Thanks for watching.